Mr.
Door, fought with law enforcement, and the recommendation would be, as I see it, a below the guideline sentencing, because the guidelines in this case, as indicated in the PSI, are 7 to 46 up to 15 years. And I see no basis, quite frankly, that the court could put on the record to find the basis for going below the guidelines. I'd ask the court to sentence within the guidelines.
I want to make sure you and I are thinking about the same information, and I'm not perhaps forgetting some. Mr. Rolla, but I presided over this trial, and the information I remember hearing at trial from the victim is that he came home to the defendant being in his home. He gave police the key to be able to get into the home, while Mr. Vanderland testified that all those things have been rifled through and gone through, and that in particular a knife was missing that was found in Mr. Gallup's pocket. Mr. Gallup not having it. I don't remember trial testimony about a door being kicked in, and that's what was referenced.
That's indicated in the victim's witness impact statement that's attached to the PSI.
Well, what I'm saying is I don't remember that from trial. And did you remember hearing that testimony from trial, or are you saying it just wasn't brought up at trial because it wasn't relevant to the charges?
It would be the latter, Judge. It wasn't relevant to the charges. Again, in fact, I think if I had brought it up at trial, there could have been an objection that this was perhaps evidence that is more prejudicial than probative.
So you think it was another bad act, and that's why you didn't seek to bring it to trial, but you think because it's contained in the victim's impact statement, I can still consider it.
That would be the people's position, yes, Your Honor.
Mr. Brown, allocution of behalf.
The police actually did have to have a key to enter the residence, not as they kicked in the door. But Mr. Gallup has a very extensive criminal history, which I'm sure the court is aware of. He suffers from some very severe mental health issues. He had a traumatic brain injury not that long ago. He was trying to get himself help for that, is looking to get into some sort of mental health treatment that affects his behavior and pretty much every part of his life. He did not have a very good childhood. Growing up, he had very little contact with his father. Mother was an alcoholic. He was abused. At only, I think, PSI says 14 years old, he was placed in foster care, began abusing substances from an extremely young age, and just had a very difficult way in life. And I don't think, and I never say that people are lost causes that they cannot change, because I do believe that they can. And he had a very slim chance, and he was really up against the wall. Being raised the way he was raised, and what he got into, and likely the people that he did hang around with. So he also asked me to mention, again, he wanted these specific words. I will do this for his behalf, on his behalf. He would like a downward departure due to his mental health issues. And I took that as basically being put into some sort of a mental rehabilitation facility, substance abuse rehabilitation facility, anything that might be inpatient, although that would affect his work, which he is fully employed now, working full-time, so he does have study employment as well. I would ask the court to consider all of that information. He did mention to me that he was in Oklahoma for a while and served 54 days in jail in Oklahoma. The credit he has here is 40 days. He inquired about credit for the whole 94 days. And so I'm looking back through my notes. While he was in Oklahoma, I did receive a message from his then girlfriend stating that he was incarcerated in Oklahoma. And I believe on that same day, I did put in a request to cancel his bond so he could accrue credit. I would ask the court to consider at the time he did serve in Indiana, or Oklahoma, even if his bond wasn't canceled. So
I'm not going to apply credit when he's serving a valid sentence in a different state. I'm legally prohibited from doing that. He's serving a sentence.
I think he was just incarcerated.
Well, if he was incarcerated, that's different. So why don't you bring forth what information you have?
Okay.
Mr. Gallup, we might hear from you in a moment, but Mr. Brown, when do you have your suggestion that you submitted some request to cancel bond? Because the PSI reflects that the 40 days was relative to bond revocation 8/28 to 9/27 of 25, and then 12/1 to 12/12 of 25. 2025, as well as the initial arrest 122 to 128. So it's a bond revocation that you're referencing, 2025.
It is.
So it's already accounted for within the PSI.
To be quite honest, I did not know it was incarceration at that time. I was informed later by his neighbor.
But it appears that's already accounted for.
That's going to be.
Any other argument, Mr. Brown?
Your Honor, I know what the court has to look at and balance with these types of cases and sentencing. I would ask the court to really look at the things that were mentioned, especially regarding his mental health, get him some kind of help so that when he eventually does get out, a period of some incarceration is definitely warranted, but again, he has already served some time. So I would ask the court to concentrate on any rehabilitative efforts on behalf of Mr. Gallo.
Thank you. Mr. Gallo, was there anything you wanted to tell me before I close sentence today?
Yes, sir. I'm not a perfect person by any means at all. And I've definitely caused my fair share of trouble. And I had basically a coming to Jesus moment in November. I got cracked in the head pretty hard. I spent about 2.5 weeks in the hospital, and with bruising on my brain, and a lot has come to figure out. I can't think right. I can't. It's just struggle to remember a lot of things, and I can do jail. I can go to jail, of course. You know what I mean? That's just up to you. But if I could get some help, the first time I ever asked for help, I've been arrested a bunch of times, but I never asked for help. I said, all right, let's go to jail. This time I need help.
What help have you sought since your arrest for this offense in January of 25?
I do, I go to my shrink, CMH in Traverse City.
In June of 2026? Last month.
Yeah, like just here recently. I started being proactive with all this. I finally been able to settle in a place where I can actually function. I'm not 100 miles away from everything. You know what I mean? My prior address was out in Marietta, and there ain't nothing out there. There ain't nothing but like many miles. You know what I mean? So I removed myself from that situation, and which was I was a victim of domestic violence, and went to the shelter in Traverse City and started being proactive for me. You know what I mean? Just all on my own. I figured I need this, and I go to I have what's called peer counselor or something like that. Eric, the guy that founded Harm Reduction in Michigan and did the mailbox boxes for the Narcan and all that, is my peer recovery coach. So he's only a phone call away. He's kind of like a sponsor, but he's busy. You know what I mean? And so I've really been taking a lot of steps to not just stay, clean, sober, fixed on the brain. I got some medical issues I got to deal with. I got supposed to get hand surgery, and lining that up, and that, obviously it takes time because I got medication and to jump to it. So, and I need to progress instead of regress, and I would like to be able to not start over exactly where I got into the situation. Because if I go sit 9 months in county jail, time served, whatever, then I'm gonna get out in the middle of winter in Gaylord again with no job, nowhere to live, and that's making it worse than it was last time. Because last time I had a place to live, I just had to get home, and I got extradited to Gaylord on a failure to appear driving without a license charge, and this conspired into all of this mess, and it turned into a mess down in Oklahoma. I lost my kids, And, you know, I fought death like 3 times last year. I did. Yeah. You send me to jail if you want to, but it ain't gonna help nothing. I'm gonna get out, still be retarded. You know what I mean? I don't know how to fix it. I'm not gonna get the help I need in jail. We get 3 house and a cot and work out all day. You know, do the same damn shit I was doing before I went in. Why not? You know what I mean? I don't know better. I'm trying to learn.
Joe, you don't seem to present the court very many options.
You know, I don't
Appears to
know.
be that your suggestion is that if I put you in jail, you're gonna get back out and reoffend. So that should be the impetus for the court to somehow give you the benefit of the doubt and give you
I mean, that's not exactly what I'm trying to say. I'm sorry.
treatment. What you just said.
I know, but I have trouble with words. You know what I mean? Like trying to describe what I'm thinking. It's brain injury. Like it's not. It comes out. It doesn't make no sense. And I need help with that. I don't know. I would appreciate some leniency so I can get help. I've said a lot of time in jail. And let me think before I talk. Is that okay?
Sorry.
I'd like for an opportunity to gain an opportunity and to maintain the opportunity to be successful as I'm doing right now. I'm doing good for the first time in a long time. And getting over the fact that I lost my kids, I'm divorced, I'm, just kind of doing it. Life on my own. I ain't got nobody to look after, and I got nobody to look after me. And I mean, yeah, I understand that I'm gonna need probation, and I need that, I did well, when I was on parole. Don't tell you that I did really well on parole. This incident, I'm not gonna reoffend, because, you know what I mean, that's my goal in life, is to be a better person than I was yesterday, every day, jail or not, you know what I mean? I just hate to stop where I'm at in my program, basically, what I got going on, and it would just stop, and I'll go sit in jail for a while, and fight for everything when I get out again. Waiting lists and appointments and housing, and it's a lot of stress. I don't know. I'm not saying that I'll revert back to, getting high and commit crimes or anything like that. I'm not gonna do that. I'm trying to be proactive with my ex-wife. We actually had a conversation this morning. Got to talk to my kids. Proactive. And I don't know, man. I try to put off a better way of doing things, and that's what I want to continue. I just throw myself at the mercy of the court to do what you feel is going to be helpful for the benefit of mental health, and that's really the problem is my brain is messed up, and I need it to get fixed. I need help with it. I finally realized it. I'm like, I got hit in the head. I'm like, dang, light bulb came on. I said, I need some help with this. I need to change something. I can't keep doing what I'm doing. I ain't getting any younger. Our kids ain't, they're getting older. I don't want to go to jail anymore. I don't. They didn't seem to do anything but just make me dependent on going to jail. You know what I mean? Like, come institutionalized. Or it's like, well, I don't have work on it, I thought road jail, and I don't want to do that. Ain't right. It's not right to get disability either. Except work for a living.
There's a lot of information for the court to consider, Mr. Gallup, including your mental health conditions, including your physical conditions and your need indicated at least for surgery for your hand. I note that you're making a request for a downward departure due to your mental health issues. I note that at least from the PSI, there's some support for your statements that you're trying to get things in order. You met and had an intake with the Lakes Community Mental Health last month. This offense happened in January of 2025, and let me be clear, you have an absolute right to maintain your innocence throughout and forever. And so the fact that you didn't comment on the offense in that way means nothing to the court. But I also comment that despite the fact that you can maintain your innocence, and I would use that against you in any way, the fact is I didn't hear a single thing about what happened in this case, the case I presided over from you. I heard about your mental health conditions, your medical conditions, and issues with your brain injury. You're entitled to bring all of that information to me, and I need to have the full context. But the full context of a felony criminal sentencing hearing also necessarily involves a factual development of what happened in this case. And I presided over the case at trial. I heard the trial testimony. Mr. Vanderland was attacked regarding his memory, regarding what he did and why. But the facts of the case, to me at least, and even though you're able to continue to maintain your innocence, the facts to me were fairly uncomplicated. They're fairly clear. You went to the home of an individual where you had stayed previously. That individual, he described, was scared to have confrontation with you. And he told you to leave, and you didn't leave. When you did finally leave by force when police were called, you had an item of Mr. Vanderland's in your possession. He denied having anything. Police found it. They matched it up with Mr. Vanderland. It was a knife that was his. It was in your pocket. And when you were arrested by police, you fought with him. You had a trial on those circumstances. And I don't recall the specifics of whatever the prosecutors offered as a plea, but your decisions continue to have impacts on you. Your decision to have a trial in this case had two important impacts on you. As a habitual fourth, because these are now your 7th and 8th felony convictions, that means the statutory maximum, where it was 4 years for larceny in a building, where it was 2 years for resist and obstruct, is now 15 years maximum by statute, by mandate, because you are a habitual fourth, you're a habitual 7th and 8th. The choices you made affect your guidelines range, and the court has to score the guidelines by preponderance of the evidence. Part of that was scored to your benefit today in terms of the amount that was taken. That lessened the overall OV level, the OV score, but not the level. Your guidelines, if you would have pled or been found guilty with no habitual, would have been 7 to 23. With habitual fourth, they're 7 to 46. A direct middle of that guidelines range, meaning if I was to just look at this as a middle of the guidelines type of a case where stolen from an individual, broken the trust of the community, and fought with police, and I just looked at it as a minimum guideline, middle of the guidelines, that's a 27-month term. That's the middle of the guidelines. You come to the court, though, at 43 years of age with significant background history, and most concerning to the court, significant background history of theft, ongoing since you were a child. You have 3 juvenile theft offenses, a larceny felony all the way back in 1996, an attempted larceny in a building also in 1996, and a retail fraud in 1998. And you have 4 different adult criminal convictions, some of them less serious than others, but all theft related. 2 retail fraud third convictions, an attempted UDAA, unlawful driving away of a motor vehicle, and a retail petty theft. Those are just the theft offenses that I counted for the PSI. And this is your 8th theft-related offense. And when you were called to task on it, fought being in the homes without permission, and you attempted to resist and did obstruct and oppose the officer's lawful commands, bash your head into the back of the car, and otherwise resist and obstruct even to when you got into the jail, you did so at your own peril, to your own detriment. Those circumstances don't reflect a basis for me to downward depart, Mr. Gallo. They reflect a need for me to be punitive, because what's happened in the past with these sentences that courts have imposed have not done anything to convince you to do things different. As soon as police got there and started telling you that you needed to leave the home of the individual that you were in, you had a basis, a legal basis to remove yourself and then to lawfully comply with police.
They didn't say that.
Mr. Gallup,
It's in the video. They didn't say that.
And what I saw
They did not say that in the video.
Mr. Gallup, convict you of resisting, obstructing lawful commands of the police. They decided that unanimously. They decided that all 12 of them. I heard that testimony. I heard what the police officer suggested, and it appeared to me to be credible, but I'm not the fact.
They didn't tell me to get up and leave nowhere,
The
man.
circumstances were that you were in a home without permission based on
I'm glad.
Vanderland's testimony, and you fought with police when they took you out of there.
I didn't do this shit, man. If I was gonna rob him, I'd have took $5,200 in his fucking snowmobile and drove off, man. I
You are
didn't do this.
entitled to maintain your innocence, but I have to impose sentence based upon a jury's determination that you did do these things. You did commit the larceny in the building by stealing at a minimum a knife that belonged to Mr. Vanderland, and you did commit the resist and obstruct. You chose to have trial knowing the risks, and the trial has consequences, which is a conviction because a jury of your peers unanimously agreed, and heightened guidelines because of your habitual fourth status. All of those things bear consideration by the court. And while I do have some belief that you want to be in a different position if you're headed to jail and or prison terms, I'm not convinced that this case is the one to downward depart and simply tell you to go into treatment. In the last 15 months, since you've been free on bond, you could have made those arrangements. And you didn't make those arrangements. Based upon the circumstances, the court views that a prison sentence is justified. I view that a prison sentence at towards the bottom end of the guidelines or the middle bottom of the guidelines is appropriate. 2 years in the state prison system, up to a maximum of 15 years for the larceny of building, up to a maximum of 15 years for the resist and obstruct charge as well. Guidelines in each of those cases begin at 7 to 46. Half of the maximum is what I'm instituting as a sentence, 24 months minimum. You do have credit for 40 days that you previously served. I hope that when you're in the system and when you get out, you seek the help that you're telling me that you need. But these circumstances justify reaction, not just ordering you to go to treatment that you could have gotten. So that is the court's order. You will be ordered to pay fines and costs as well. Those fines and costs include a total of $130 for crime victim assessment, court costs of $325, $130 state costs. Under these circumstances, I'm not ordering attorney fee reimbursement of $350. By state law, those fines, costs, and assessments are due today. If you don't pay them within 56 days of today's date, 20% late fee gets added on. You have an automatic right to leave, automatic right to seek the appeal. The Court of Appeals must hear your appeal if you timely file it. Your attorney can go over those appeal rights with you. The first copy, you're just going to sign to indicate that you bought the appellate rights. The bottom 2 copies are yours, and you have the automatic right to seek leave to appeal.
Your Honor, for the record, those rights have been acknowledged and attended that acknowledgement.
You have those appellate rights with you, Mr. Gallo?
Yeah, I got it.
You have the automatic right to seek that leave, seek that application, and get an absolute right to appeal, but you need to fill out those rights within the time period stated on the form.
Yeah, it don't matter. I'll be, by the time we get to the appeal court, I'll be all right. It don't matter, man.
That's the sheriff's department, yeah, arrange for your transportation.
Shit, dude. All right. No phone, man. So beautiful. Yeah. Okay. Bill, they'll be gone for 2 years. You hear that? Yeah. Love you, man.